Recently, the Uttarakhand government has created news by passing the Uniform Civil Code Bill 2024 in the State Assembly. Uniform Civil Code has been prescribed under Article 44 of the Indian Constitution, which says that the state shall endeavour to secure for its citizens a uniform civil code throughout the territory of India. What does Uttarakhand's UCC bill say? Firstly, all scheduled tribes, that is, tribal communities, have been kept out of the scope of this bill, and this bill applies to marriage between a man and woman only. Focus has been given to rights of children born out of a marriage or live in relationship, that is, irrespective of whether the child is legitimate or illegitimate, his or her rights have been ensured. Second, for Muslims, UCC makes the minimum age of marriage to 18 years for women and 21 for men. This is done in line with Hindu Marriage Act 1955 and Special Marriage Act 1954. This differs from Islamic personal law, where marriage can take place where the girl has attained puberty, generally assumed at 13 years. This is contrary to the provisions of Protection of Children from Sexual Offences Act or POCSO. UCC also draws inspiration from the Indian Succession Act 1925 to change the provisions of succession in Muslim law. As of now, Muslims can transfer up to one-third of their property to anyone of their choosing through a will, and the rest goes to the legal heirs. However, if there is no will, the property must be divided among all individual legal heirs. UCC provides for either testamentary succession, that is where a will has been left behind, as well as intestate succession, that is where there is no will. The property passes on to Class 1 heirs, which include children, widow, and parents, and in absence of Class 1 heirs, it can go to Class 2 heirs like siblings, grandparents, etc. Acts like bigamy, polygamy, iddat, nikah halala have been criminalized. Thirdly, for Hindus, UCC mainly changes succession by doing away with the distinction between ancestral and self-acquired property. Under Mitakshara school of law, ancestral property is held jointly across 4 generations in a family, that is, children, grandchildren, great-grandchildren, etc. Each of them is a co-parsoner, that is, have a stake in the property. Ancestral property cannot be sold by any individual co-parsoner. While for self-acquired property, the father may dispose of his property as per his own will. Parents, that is mother and father, have been made Class 1 heir in case of intestate succession. Fourthly, it has made mandatory the registration of any live-in relationship within the state's jurisdiction, irrespective of whether the people in such relationship are from Uttarakhand or not. A statement has to be submitted to the registrar, who will conduct an inquiry and either register the relationship or refuse it. Partners can terminate the relationship by submitting a termination statement. Women partners can claim maintenance from their partners, and children born out of such relationships are considered legitimate. It could be said that the UCC passed by the Uttarakhand government might provide a roadmap to the central government when time comes for it to create its own national uniform civil code. This brings us to the end of our video. Please like, share and subscribe Exact IAS on YouTube and follow us on Instagram. Thank you for watching this. I will see you in our next.